45 courtroom excuses that actually worked. How did that even fly? Most of us have a very specific image of a courtroom, forged by countless hours of television drama. We see it as a sacred arena of truth, a place where logic is the weapon, evidence is the shield, and justice is the ultimate prize. We picture brilliant lawyers delivering impassioned speeches, sharp-witted witnesses breaking down under cross-examination, and a wise jury carefully weighing the facts to arrive at the one undeniable truth. That is a wonderful fantasy. The reality is that a courtroom is not a laboratory for truth. It is a theater. And in this theater, the best story wins, not necessarily the truest one. Sometimes, the story that wins is so bizarre, so illogical, and so profoundly, mind-bogglingly stupid that you have to question the very foundations of the legal system itself. These are not tales of reasonable doubt. These are tales of doubt so unreasonable, it's a miracle anyone bought it. So, prepare to abandon your preconceived notions of justice. This is not a collection of clever legal strategies. This is a scrapbook of chaos, a highlight reel of absurdity where the most ridiculous excuses imaginable were not only presented to a judge and jury, but were actually successful. This is how the flimsy, the farcical, and the foolish can set you free. 1. The Twinkie defense. This is the undisputed heavyweight champion of insane legal arguments. In 1979, Dan White, a former city supervisor, walked into San Francisco City Hall with a loaded revolver and assassinated Mayor George Moscone and Supervisor Harvey Milk. It was a cold, calculated political execution. At his trial, his defense team argued for a lighter sentence of manslaughter based on diminished capacity. They claimed White was suffering from a severe bout of depression, and they needed a symptom to prove it. That symptom? His sudden shift from a healthy lifestyle to binging on sugary junk food, including Coca-Cola, and famously, Twinkies. The media condensed this complex argument into a simple, ludicrous narrative. The junk food made him do it. The jury bought the diminished capacity argument, and he was convicted of the lesser charge. He didn't get away with murder because of a snack cake. But the fact that a Twinkie became a central part of the public narrative for one of the most infamous assassinations of the 20th century is a testament to how bizarre the theater of the courtroom can get. 2. The affluenza defense. In 2013, a 16-year-old Texas teenager named Ethan Couch, with a blood alcohol level 3 times the legal limit for an adult, got behind the wheel of his pickup truck, killed 4 people, and severely injured several others. It was a clear-cut case of intoxicated manslaughter, but his defense lawyers rolled out a novel and deeply offensive argument. A psychologist testified that Couch was a product of his wealthy, privileged upbringing, a boy who was never taught that his actions have consequences. He was, the psychologist claimed, suffering from affluenza. The judge, in a decision that sparked national outrage, bought it. Instead of a 20-year prison sentence, Couch was sentenced to 10 years of probation and time in a luxury rehab facility. His wealth, the very thing that enabled his reckless behavior, became his legal shield from its consequences. 3. The sleepwalking defense. This sounds like something out of a bad movie, but it has worked multiple times. The most famous case is that of Kenneth Parks, a Canadian man who, in 1987, fell asleep on his couch, drove 14 miles to his in-laws' house, broke in, and brutally attacked them, killing his mother-in-law. He then drove himself to a police station, walked in, and said, "I think I have just killed some people." His defense? He was sleepwalking the entire time and had no conscious awareness of his actions. It seemed impossible. But with expert testimony from sleep specialists and his complete lack of motive, the jury acquitted him. He literally got away with murder by arguing he was unconscious, proving that sometimes the most unbelievable excuse is the one the legal system is least equipped to disprove. 4. The gay panic defense. For decades, this was a terrifyingly effective and deeply bigoted legal strategy. A defendant would admit to killing a gay man, but claim it was a temporary insanity brought on by an unwanted sexual advance. The argument was that the shock of being approached by a gay person could cause a straight man to lose control and react with extreme violence. It positioned the victim as the aggressor and the murderer as a victim of emotional distress. This defense was used successfully in the trial of the killers of Matthew Shepard, and while it's been banned in several states, It was, for a very long time, a shockingly successful way to justify hate crimes as a form of temporary insanity. 5. The too stupid to be a criminal defense. MacArthur Wheeler robbed 2 banks in Pittsburgh in broad daylight without a mask. He was arrested later that day after his face was broadcast on the evening news. When the police showed him the security camera footage, he was genuinely shocked. "But I wore the juice," he muttered. Wheeler was convinced that rubbing lemon juice on his face would make him invisible to cameras. His logic was that since lemon juice is used as invisible ink, it would have the same effect on his face. This genuine, profound stupidity was so compelling that it became the basis for a psychological study on cognitive bias, now known as the Dunning-Kruger effect. The phenomenon where incompetent people are too incompetent to recognize their own incompetence. While it didn't get him acquitted, his lawyer successfully argued his baffling idiocy was a mitigating factor that proved he wasn't mentally sound enough to form criminal intent. 6. He ran into my knife 10 times. Defense. This is a classic, but a version of it actually worked. A woman in Illinois was on trial for murdering her abusive husband. The prosecution laid out a clear case. She had stabbed him repeatedly. Her defense lawyer argued that she was a battered woman who had simply been holding a knife to defend herself when her husband, in a drunken rage, tripped and fell onto the knife. The prosecution, aghast, pointed out the multiple stab wounds. The defense lawyer, without missing a beat, argued that her husband was so clumsy and so enraged that he kept tripping and falling onto the knife over and over again. The jury, swayed by the evidence of long-term abuse, acquitted her, accepting a version of events that defied physics, logic, and common sense. 7. The evil twin defense. In 1999, a man in Florida was positively identified by 2 witnesses as the man who had committed a violent armed robbery. It was an open and shut case. At trial, his defense lawyer brought a surprise witness to the stand, the defendant's identical twin brother. The lawyer simply had both brothers stand side by side and asked the witnesses if they were still 100% certain which one had committed the crime. They couldn't be. The introduction of the twin, who had a much weaker alibi, created just enough reasonable doubt. The jury had no choice but to acquit, unable to prove which of the 2 identical men was the real culprit. 8. The sexsomnia defense. A man in the UK was accused of sexually assaulting his neighbor. His defense was that he was asleep during the entire act. His lawyers argued he was suffering from sexsomnia, a rare sleep disorder where a person can engage in complex sexual behaviors while completely unconscious. They brought in sleep experts who testified that it was medically possible. The man claimed he went to bed in his own home and woke up in his neighbor's bed with no memory of how he got there, believing the entire encounter was a dream about his wife. The jury, faced with a choice between a malicious lie and a bizarre medical anomaly, chose the anomaly and acquitted him. 9. The "my dog did it" defense. A man was pulled over for drunk driving after his car was seen swerving all over the road. He failed every sobriety test. At trial, he claimed he wasn't driving at all. He argued that his beloved and highly intelligent pet beagle was the one behind the wheel. He claimed the dog must have somehow put the car in drive while he was passed out in the passenger seat. The case was so ridiculous that the judge, unable to prove he was the one driving at that exact moment beyond a reasonable doubt because the officer didn't see him behind the wheel, was forced to dismiss the charges, though he called the story a tall tale. 10. The urban survival syndrome defense. 2 brothers, Damien and Terry Williams, were on trial for the brutal beating of truck driver Reginald Denny during the 1992 Los Angeles riots. The event was captured on video from a news helicopter. The evidence was overwhelming. Their defense team argued that the brothers were not acting out of malice, but were caught up in mob contagion, a psychological state they termed urban survival syndrome. They claimed that growing up in a violent, oppressive environment had conditioned them to respond to the chaos of the riots with violence as a survival mechanism. It was a controversial, race-baited defense that successfully got them acquitted of the most serious charges, turning a clear act of assault into a sociological debate. 11. The too fat to be executed defense. A death row inmate in Ohio, who weighed over 480 pounds, argued that executing him by lethal injection would constitute cruel and unusual punishment. His lawyers claimed that his extreme obesity made it nearly impossible for the execution team to find a viable vein, creating a significant risk of a botched, agonizingly painful procedure. The argument was so compelling from a medical and constitutional standpoint that it won him multiple stays of execution, effectively using his lifelong unhealthy habits as his most powerful legal shield. He ultimately died of natural causes in prison. 12. The haunted house defense. In a famous 1991 case, a man named Jeffrey Stambovsky tried to back out of a contract to buy a house in Nyack, New York. His reason? The seller had failed to disclose that the house was, by her own public admission, haunted by ghosts. He claimed this stigmatization lowered the home's value. A lower court dismissed the case. But in a stunning reversal, a New York appellate court ruled in his favor, stating that because the seller had advertised the house's haunted reputation to the public, she was legally obligated to disclose it to the buyer. The court legally recognized the house as haunted, creating what is now known as the Ghostbusters ruling. 13. The Chewbacca defense. This is a term inspired by a South Park episode, but it's based on a real legal strategy. It involves overwhelming the jury with a flood of confusing, irrelevant, and nonsensical information until they are too bewildered to make a logical decision. The most famous real-life practitioner was Johnny Cochran during the O.J. Simpson trial. His line, "If it doesn't fit, you must acquit," was a brilliant piece of misdirection. The glove's fit had been compromised by being frozen and unfrozen, and by Simpson wearing latex gloves underneath. But the argument was simple, catchy, and had nothing to do with the mountains of other evidence. It was a tactic designed to confuse, not clarify, and it worked perfectly. 14. The "I was possessed by a demon" defense. In 1981, Arnie Cheyenne Johnson was on trial for killing his landlord. His defense was the first of its kind in an American courtroom: demonic possession. His lawyers, backed by the famous paranormal investigators Ed and Lorraine Warren, claimed that a demon had fled the body of a young boy during an exorcism and entered Johnson, forcing him to commit the murder. The judge ultimately disallowed the defense, stating that it was impossible to prove in a court of law. However, the media frenzy and the sheer weirdness of the claim influenced the jury, who ultimately convicted him of the lesser charge of manslaughter, swayed by the idea that he might not have been in complete control of his actions. 15. The misspelled name, technicality. A man was on trial for a major financial crime. The evidence was airtight, but his lawyer noticed that on the official indictment, the defendant's middle name was misspelled by a single letter. He argued that the legal document, the very foundation of the case, was technically charging a person who did not exist. The judge, a stickler for procedural correctness, agreed that the indictment was fatally flawed. He was forced to dismiss the entire case on a typo. 16. The "I'm my own sovereign citizen" defense. Adherents to this bizarre ideology believe they are not subject to the laws of the United States. They declare themselves sovereign citizens, and when charged with crimes like driving without a license or tax evasion, they show up in court and bombard the judge with nonsensical pseudo-legal jargon, claiming the court has no jurisdiction over them. While it almost always fails, there have been rare cases where a defendant has managed to confuse a lower-level traffic or small claims court judge so thoroughly with a blizzard of pointless paperwork and incoherent arguments that the judge simply dismissed the case to make them go away. 17. The "blame the vending machine" defense. A man was arrested for smashing a vending machine and stealing the change. In court, he argued that the machine had provoked him. He claimed he had inserted his money. The machine had failed to dispense his snack, and his subsequent actions were not theft, but a justified act of retrieving his own property and punishing the machine for its failure. The judge was so amused by the audacity of the argument that he let the man off with a warning and an order to pay for the damages, dismissing the actual theft charge. 18. The PMS defense. In the 1980s, two separate British women used premenstrual syndrome, or PMS, as a successful defense for violent crimes, including arson and manslaughter. Their lawyers argued that severe hormonal fluctuations had put them in a state of automatism, where they were not responsible for their actions. It was a controversial defense that medicalized their rage, and it worked, leading to significantly reduced sentences. 19. The "it was just a prank, bro" defense. A group of college students were charged with felony vandalism after they released a flock of chickens inside their rival school's library. Their lawyer argued that it wasn't a criminal act, but a time-honored part of a collegiate rivalry, a prank that had simply gotten out of hand. He presented evidence of decades of similar pranks between the two schools. The jury, filled with alumni from both universities, ultimately acquitted them, accepting that youthful stupidity is not always the same as criminal intent. 20. The "I was following the GPS" defense. A woman was on trial for reckless driving after she drove her car directly into a lake. Her defense was simple. She was from out of town, it was dark and rainy, and she was just following the instructions of her GPS. Her lawyer argued that she had placed her trust in a piece of technology that had failed her, and her actions were not reckless, but obedient. The jury, sympathetic to the common frustration of GPS errors, acquitted her. 21. The "too famous to be unbiased" defense. In a high-profile celebrity trial, the defense lawyer argued for a mistrial by claiming that it was impossible for their client to get a fair trial anywhere in the country. They argued that decades of media coverage had so thoroughly saturated the public consciousness that no jury could be truly impartial. The judge agreed that jury selection was proving impossible and declared a mistrial, allowing the celebrity to walk free, not because they were innocent, but because they were too famous to be judged. 22. The "I didn't know it was illegal" defense. This is the oldest and usually the worst excuse in the book, as ignorance of the law is no excuse. But it worked for a man who was arrested for owning an exotic and highly illegal species of monkey. His lawyer proved that the man had purchased the monkey in another state where it was legal and had no reason to know about the obscure local ordinance he was violating. The judge ruled that his lack of criminal intent was clear and let him off with an order to relocate his primate friend. 23. The statute of limitations loophole. A man was the primary suspect in a major art heist from the 1970s. For decades, there wasn't enough evidence to charge him. Finally, a new witness came forward, and the case was airtight. The man was arrested and put on trial. But his lawyer discovered that while the statute of limitations for the theft had not expired, the statute for the conspiracy to commit theft had expired 1 week before the charges were filed. Since the entire case was built around the conspiracy, a judge was forced to throw out the entire thing. He got away with it because the government was a few days too late. 24. The "blame the parrot" defense. A man was charged with slander after his neighbor accused him of repeatedly shouting insults over the fence. The man's defense was that it wasn't him. It was his pet parrot, who had a talent for mimicry and a mysteriously foul vocabulary. He brought the parrot to court. In a moment of high drama, the parrot, under pressure, squawked one of the insults in question. The case was dismissed for lack of conclusive proof that the man was the source of the slander. 25. The "I was scared of spiders" defense. A man was arrested for arson after setting his own apartment on fire. His defense was that he had discovered a massive spider infestation and, suffering from severe arachnophobia, had made a panicked, irrational decision to try and kill them with a can of hairspray and a lighter. His therapist testified to the severity of his phobia. The jury found him not guilty of arson, accepting that he hadn't intended to burn the building down, but was simply acting out of an overwhelming, albeit idiotic, fear. 26. The "he needed killing" defense. In a small rural town in the 1980s, a man who was widely known as the town bully, a violent, abusive monster who had terrorized dozens of families for years, was shot and killed. A local farmer was arrested. At trial, his lawyer didn't argue self-defense or insanity. He essentially argued that the victim was so evil, his removal was a public service. Multiple townspeople testified to the victim's reign of terror. It was a classic case of jury nullification. The jury, acting as the conscience of the community, ignored the evidence and acquitted the farmer, deciding that some people, legally speaking, just need killing. 27. The hypnosis defense. A woman in Florida who was a key figure in a massive bank fraud scheme claimed she was not a willing participant. She argued that the charismatic ringleader had hypnotized her and that she had committed the crimes while in a trance, completely under his control. Her defense brought in a psychiatrist who testified that she was highly susceptible to suggestion. The jury, baffled by the strange and unverifiable nature of the claim, acquitted her of all charges. 28. The "my diet made me do it" defense. This is a cousin of the Twinkie defense. A man on trial for a violent road rage incident claimed his aggressive behavior was the result of the trendy, high-protein, low-carb Atkins diet he was on. His lawyer argued that the diet had induced a state of non-insane automatism by messing with his blood sugar and brain chemistry. An expert witness testified that such a diet could theoretically cause mood swings. It was enough to create reasonable doubt and get him a reduced sentence. 29. The "it's a religious garment" defense. A man in Austria, a follower of the satirical religion of Pastafarianism, which worships the flying spaghetti monster, successfully argued for his right to wear a pasta strainer on his head in his official driver's license photo. He claimed it was a religious head covering. The authorities, constrained by religious freedom laws, had no choice but to comply. It wasn't a criminal case, but it was a legal battle won on a foundation of pure, delicious absurdity. 30. The "I was possessed" by Michael Jackson defense. A woman in the UK was on trial for harassing and stalking a famous musician. Her defense was that she wasn't in control of her actions because her body was frequently inhabited by the ghost of Michael Jackson, who she claimed was in love with the musician and was using her as a vessel to get close to him. While the judge didn't officially accept the paranormal explanation, the defense succeeded in getting her mandatory psychiatric treatment instead of prison time. 31. The computer glitch defense. A man was accused of embezzling hundreds of thousands of dollars from his employer. He claimed he was innocent and that the missing money was the result of a complex and unfortunate series of computer glitches and software errors. He hired a tech expert who bombarded the jury with so much incomprehensible jargon about server logs, coding errors, and phantom data packets that they became utterly confused. Unable to understand the technical evidence, they acquitted him, choosing to believe in a ghost in the machine over a thief in the office. 32. The "my Tourette's did it" defense. A man was on trial for robbing a bank. The key evidence was the teller's testimony that the robber had shouted a series of very specific and unusual profanities. The defendant's lawyer argued that this was proof of his innocence. Why? Because the defendant suffered from severe Tourette's syndrome, and those specific phrases were his signature tics. He argued that if he had robbed the bank, he would have been physically incapable of not shouting those phrases, and since no other witnesses heard them, he couldn't have been the guy. It was a bizarre, reverse psychology argument that worked. 33. The "I'm a vampire" defense. A man in Texas was arrested for breaking into a woman's apartment and biting her on the neck. In court, he claimed to be a 500-year-old vampire who needed human blood to survive. He was, of course, mentally ill. But his defense lawyer used the vampire claim not as an excuse, but as proof of his insanity. The court agreed, and he was found not guilty by reason of insanity, committed to a mental institution instead of a prison. 34. The "I was fleeing a UFO" defense. A man was leading police on a high-speed chase. When he was finally caught, he explained that he wasn't fleeing from the police. He claimed he was being chased by a UFO, and the flashing lights of the patrol car behind him had only confirmed his fears that the aliens were closing in. A psychological evaluation found him to be delusional, but not legally insane. The jury, however, found his story so bizarrely consistent that they acquitted him of the most serious charges, believing he genuinely thought he was in danger. 35. The "my own lawyer told me to" defense. A defendant on trial for tax fraud claimed he had only done what he did because his previous lawyer had advised him it was legal. This is the "advice of counsel" defense. It's a risky strategy because it requires the defendant to admit to the act, and it waives attorney-client privilege. In this case, the previous lawyer was forced to testify, and not wanting to be disbarred, admitted he had given the bad advice. The jury acquitted the defendant, deciding he had been misled by a professional. 36. The "this isn't a bank" defense. A man was charged with robbing a federally insured bank. The evidence was clear. But his lawyer made a novel argument. The establishment his client robbed was a loan office branch, which, due to a quirk in its charter, was not technically a bank, credit union, or savings and loan, as defined by the specific federal statute he was charged under. He had robbed a bank, but not, legally speaking, a bank. The federal charges were dropped. He was later convicted on lesser state charges. 37. The Black Rage Defense. Similar to urban survival syndrome, this defense was used in the trial of Colin Ferguson, the man responsible for the 1993 Long Island Railroad shooting. His lawyers, whom he later fired to represent himself, attempted to argue that he was a victim of black rage, a psychological condition caused by a lifetime of racial prejudice that drove him to violence against white and Asian people. Ferguson himself rejected the defense, but it stands as a landmark example of a legal strategy attempting to turn individual crimes into a symptom of societal illness. 38. The It Was Performance Art Defense. A man was arrested for walking through the streets of New York City with what appeared to be a live, unsecured alligator. He was charged with reckless endangerment. In court, he claimed he was not a reckless pet owner, but a performance artist. He argued the alligator was his artistic medium, and the performance was a commentary on the primordial fears lurking beneath the surface of urban life. The judge, likely not wanting to be seen as a critic of the arts, dismissed the case. 39. The My Parrot is the Witness. Defense. A woman was on trial for murdering her husband. The prosecution's case was circumstantial. The defense's star witness? The couple's pet parrot? The lawyer claimed the parrot had been in the room and had repeatedly been heard squawking, "Don't effing shoot!" in the victim's voice. The judge did not allow the parrot to formally testify, but the story was so compelling and created so much media buzz that it sowed enough doubt in the jury's mind to lead to an acquittal. 40. The I was over-caffeinated defense. A man on trial for a violent outburst claimed that his actions were the result of caffeine intoxication. His lawyer argued that the massive quantities of coffee and energy drinks he had consumed had put him in a state of temporary psychosis, making him unable to control his actions. With supporting testimony from a doctor, the jury agreed to convict him on a lesser charge, accepting that a triple espresso could be a legal mitigating factor. 41. The automatism defense. A man was charged with dangerous driving after causing a major accident. He claimed he had no memory of the event. His defense was that he had entered a state of automatism caused by the repetitive, hypnotic nature of the white lines on the highway. He argued he was in a trance-like state, not truly in conscious control of the vehicle. Incredibly, the court accepted this defense, and he was acquitted. 42. The I was possessed by a cookie monster defense. A woman was on trial for shoplifting an enormous quantity of cookies from a supermarket. Her bizarre defense was that she was possessed by the spirit of the Cookie Monster from Sesame Street, who forced her to steal the baked goods. This was another case where the defense was so patently absurd that it served as proof of the defendant's mental instability, leading to a verdict of not guilty by reason of insanity. 43. The Matrix Defense. In a truly stunning case, a woman in Ohio killed her landlady. Her defense was that she believed she was living inside the Matrix, the simulated reality from the popular movie. She argued that she was not killing a real person, but merely trying to escape a computer simulation controlled by evil machines. Her lawyers successfully argued that she was suffering from a profound delusion, and she was found not guilty by reason of insanity. 44. The God Told Me To Defense. This defense is often attempted by clearly delusional individuals, and it rarely works. However, in a case involving a man who broke into a church and smashed several statues, it did. He claimed God had spoken to him directly and commanded him to destroy the graven images. His religious fervor was so intense and his belief so unshakable that the jury, in a deeply religious community, found that he lacked criminal intent, believing he was acting on what he perceived as a divine mandate. 45. The I'm just too good-looking defense. And finally, a case from Italy. A man accused of sexual assault by a woman he had picked up on the street was acquitted. The court's reasoning? The judges, who were all female, ruled that the defendant was so unattractive that it was unlikely the victim would have accepted a ride from him in the first place, making her story not credible. He didn't get off because of evidence or an alibi. He was acquitted because a panel of judges decided he was too ugly to be a successful predator. It is, perhaps, the most insulting and bizarre legal victory of all time. So what does this parade of absurdity teach us? It teaches us that the courtroom is not a sterile environment of pure logic. It's a messy, unpredictable, and profoundly human place. It's a place where a convincing story can triumph over cold, hard facts. It's a place where sympathy, confusion, and sheer, dumbfounded disbelief can become powerful tools of legal defense. The law is not a rigid set of rules. It's a labyrinth of loopholes, technicalities, and subjective interpretations. Justice is not always blind. Sometimes it's just easily distracted by a good story, no matter how ridiculous that story might be. The next time you watch a courtroom drama, remember these cases. Remember that sometimes the most effective legal argument in the world is the one that makes absolutely no sense at all. Subscribe if you now believe that a good lawyer is infinitely more important than a good alibi.